Good morning, good afternoon, and good evening to wherever you are watching from and whenever you are watching. Welcome to the webinar of Kaho'ohanohano versus State of Hawaii, Protecting Access to Safe, Equitable, and Culturally Informed Midwifery Care. This program is sponsored by the ABA section of the Civil Rights and Social Justice, the ABA Commission on Domestic and Sexual Violence, the National Association of Women Lawyers, Native Hawaiian Legal Corporation, Santa Clara County Bar Association Women's Lawyers Section, among others. And it's part two in the Reproductive Rights Initiative's In Conversation series exploring the complex and rapidly changing legal landscape of reproductive rights in the US. CRSJ is actively planning additional programming on a variety of issues, so please visit theamericanbar.org/CRSJ for updates on these programs. Today, we will be talking about access to midwifery and doula services and its impact on maternal health care. Earlier this year, a landmark suit, Kaho'ohanohano versus State of Hawaii, was filed on behalf of midwives and pregnant people to combat a new midwifery restriction in Hawaii that prevents pregnant individuals from receiving pregnancy and birth care from trusted and culturally informed midwives. Although this new law claims it is not a barrier to care, under this law, many Native Hawaiian families and others would no longer be able to access traditional care for fear and threat of prison and fines. Join us for a conversation with attorneys leading this suit to discuss the case and what's at stake for birthing people in Hawaii and beyond. My name is Nicole Vasquez Del Favero. I am an assistant counsel with the Department of the Navy, Office of the General Counsel, as my day job. And in my more fun time, I enjoy being a member of the Reproductive Rights Initiative. And I'm really thrilled to be here today with Hillary Schneller, Senior Staff Attorney at the Center for Reproductive Rights, and Kersha Durant, Litigation Director at Native Hawaiian Legal Corporation. Thank you both so much for joining us for this series.
Thank you.
Thank you.
So I will go ahead and start with allowing you both to introduce yourselves a bit. Hillary, if you would like to start.
Sure. So thank you for having both of us. As you mentioned, I'm Hillary Schneller. I'm a senior staff attorney at the Center for Reproductive Rights. The Center is a global human rights organization that uses the power of the law to ensure that reproductive rights are guaranteed as fundamental human rights. And we work across the globe. We have offices here in the US, as well as in Geneva, Nairobi, and Bogota, among others. And in the US, we work through human rights advocacy, state and federal policy advocacy, as well as litigation. So I have been a litigator at the center for almost 10 years now. A few years ago, I was co-counsel in the Dobbs litigation, defending the right to abortion at the US Supreme Court. And today I'm leading several cases to secure and expand access to abortion, as well as to respectful maternal health care, including the case that we are going to talk about more today.
Kirsha, go ahead.
So as you mentioned, first of all, mahalo for the opportunity to talk about this really important case. As you mentioned, I'm the litigation director at the Native Hawaiian Legal Corporation. And the Native Hawaiian Legal Corporation is a nonprofit public interest legal services organization, and it's the only law firm exclusively dedicated to Native Hawaiian rights. And we are actually celebrating our 50-year anniversary of being in existence this year. The mission of Native Hawaiian Legal Corporation, or NHLC, as some people refer to it, is to protect and advance Native Hawaiian identity and culture. And the way that we do this is by integrating Kanaka Maoli, or indigenous Hawaiian values, into the practice of law and advocacy in courts and before administrative agencies. NHLC handles a wide breadth of cases in a variety of areas, and our work contributes to the protection and preservation of Native Hawaiian culture, identity, health, and well-being. We provide Native Hawaiian families and communities with legal advocates to navigate legal challenges in which Native Hawaiian rights are at stake. And this protection of traditional and customary practices, which was part of this case, is one of the areas or one of the types of work that we do as part of our advocacy.
Wonderful. Thank you both again for being here. I'm excited to dive into this case with you. So with that, I will go ahead and open with our first question. Can you take us through the genesis of this case?
Yes, so I will start, and then Kirsha, feel free to sort of jump in. So in July of last year, of 2023, a midwifery restriction law took full effect in Hawaii. The law requires essentially anyone providing information, care, and advice during pregnancy, birth, or postpartum to have a specific state license. People without a proper license are subject to imprisonment and fines. And then the law uses arbitrary and discriminatory criteria to determine who is even eligible for this specific license. So it would require practitioners, including those who have served their communities for years, to be re-educated through Western programs at one of 8 approved schools, sort of 8 schools that are approved by the law, none of which are even located in Hawaii. So last spring, an Indigenous midwife with whom the center has been working for many years on human rights advocacy alerted us to this change in the law as she was working with advocates in Hawaii who were trying to change the law legislatively. So we got connected with this just amazing and diverse coalition of midwives, student midwives, mamas, parents, doulas, and other birth workers and community members who were concerned about the impact that this law would have on maternal health care, on access to basic services, and to culturally competent care. We had many Zoom calls across, many time zones, and also traveled in person to meet folks, which, nothing can really replace that face-to-face discussion. And we heard a lot of fear and concern, fear that the law was preventing people from accessing prenatal care and birth support when they can't call on the midwives they trust. And it was disrupting care that had been provided in community for decades and sometimes generations. This was all particularly scary for people in rural areas, of which there are many across the island state. And people must travel hours or sometimes to another island to access care at a hospital. There was also a real fear for future generations, whether folks' own children would be able to make their own choices about pregnancy and birth, and whether their traditions, in particular Native Hawaiian traditions around birth, would survive if practitioners couldn't practice those anymore because doing so was criminalized. So we worked with this coalition on the legislative side, as well as starting to consider whether a lawsuit would make sense. So the center was co-counseling with Perkins Coie, a law firm that has provided us huge support in this case. And we also reached out to Native Hawaiian Legal Corporation, given this very clear concern about the impact on Native Hawaiian traditions, an area that we are not expert in, but NHLC absolutely is. So I don't know, Kirsha, if you wanted to jump to sort of add some context to NHLC's interest in co-counseling in this case.
Sure, absolutely. As I mentioned, we are the only law firm in the world that is dedicated exclusively to Native Hawaiian rights advocacy. So that really uniquely positions us to assist in this case because of our long history advocating and navigating the legal landscape for protection of traditional and customary practices. When we were approached by the center, the impact that we observed that this legislation presented, the impact to practitioners was very dire. Part of what has been interpreted through case law with respect to protections of traditional and customary practices is that while the state has the ability to reasonably regulate the manner in which practices can occur, that they cannot be regulated out of existence. So if legislation or any type of essentially rulemaking even extends so far that it threatens the extinction of a practice, it's essentially the eradication of a culture and the identity of Hawaiian people. So that was very significant for us because the types of practices that we are talking about in this case are practices known as pale keiki, Kahoʻohanono, and hanau birthing practices, which is essentially Native Hawaiian traditional birthing practices. And they are a unique and specialized subset of some of the more generally and more commonly recognized practices within our community. And why that is important is because it is so specialized. There are very limited amount of people remaining that have the ability to engage in that practice, to teach and share it, and ultimately to perpetuate it. So the fact that there was legislation that effectively created a barrier for practitioners to continue engaging in those practices meant that it was threatening the extinction of the practice. So it was more than just an unreasonable regulation. It was dire because the practice itself was at risk of extinction.
Wow. Grateful that you were both on this case. I know in reading about this case that you had a 4-day preliminary injunction hearing in June. Can you share some highlights?
I'll start with that one. Just going chronologically, the very first day of the hearing, this group that Hillary talked about, this amazing group of mamas, midwives, doulas, they gathered outside of the courthouse together to pule or to pray, for this hearing and what was going to happen, but also for protection and guidance to be bestowed on us as the counsel that we're going to be standing up for them in that courtroom. And one of the things that they did that for me personally was really meaningful is that they gave all of the counsel lei. So lei are traditional Hawaiian flower necklaces is how most people identify them. And they provided us all with a specific type of lei, which is a lei la'i, or la'i is also known as tea leaf. And it's a leaf that's been twisted to essentially create a twisted lei that you wear. But there's cultural significance for that particular plant. That plant is used for protection. It's used for healing. And having our legal team adorned in that protection by this group that was really trusting us with going in there and being their voice and helping them to tell their stories. Having that during the proceeding on the first day was really powerful for me. I felt like it wrapped us all in protection so that we could really focus on what we needed to do in there and to be able to do our best to advocate for them. And that was a really special moment. I think it also, it really encapsulates everything that NHLC does. Like I mentioned earlier, it's bringing Hawaiian culture into courtrooms. It's being able to present a Hawaiian worldview, way of living, life ways, practices. It's educating and providing that information to the court so that they can properly understand and interpret the laws that protect these practices, but really our culture and our identity and our way of being. So to have that image reflected not only in what we were arguing, but how we presented ourselves as a co-counsel legal team of people from very different areas, but all really united in this one path of advocacy was really, really special. And that's a memory that I'm going to take away from it as being very powerful.
Yeah, I mean, I will second that highlight and sort of add, for me, I mean, just helping our clients prepare and then witnessing their testimony throughout the week was incredibly powerful and felt groundbreaking, felt different than other hearings I have been in. So many of our clients shared their own personal, whether joyful or traumatic, birth and pregnancy stories, what it meant when they could have access to their chosen midwife, cultural practitioner, and what it meant when they couldn't, have that supportive care. And, there are two key claims that we brought in the preliminary injunction part of the case. One was about this law, as Kersha was describing, threatens to eradicate Native Hawaiian traditional birthing practices. And the other is about reproductive autonomy, that people have a privacy right, a reproductive autonomy right to decide where and with whom they birth. And it was sort of amazing to see those two claims just working so well together in our client's testimony, that the cultural significance of the decision where and with whom to birth just, it sort of became so intuitive and very powerful, and sort of kind of know you're doing something right when the legal arguments are intuitive and they just flow naturally from the stories our clients were sharing. And it was hard. It was hard for our clients to share some of those very personal experiences and the fears about what this law was doing in the moment, right? This is not a future looking concern. This was, every day I am concerned that I have to turn people away, or that if I become pregnant, I'm not going to be able to have the trusted practitioner I had for my last pregnancy. So helping our clients through that and just witnessing their power up on the stand, I think was, a highlight. I'm not sure I will be able to top in other cases, but I'm glad it came through in this one.
I just want to add that I think our clients really exhibited a lot of courage. Like Hillary shared, much of what they testified to were very deeply personal and intimate parts of their life that they chose to share. And for cultural practitioners in particular, that it takes a lot of courage to come into a courtroom and to essentially have your practices, which within Hawaiian culture, there isn't one set way to engage in practices. Practices are passed down through ohana or through family. So practices and approaches differ, but they're still all part of those traditional and customary practices. So when practitioners come into courtroom and they talk about what they do and where that came from, there's always that vulnerability of someone is going to be picking that apart or trying to challenge it or trying to show that for some reason it's not a traditional practice. And so the amount of courage that these individuals exhibited by just sharing their personal truths was really, really powerful. The other thing I wanted to add is that it was very meaningful to watch how we look at law on paper and we read it and we think we understand what it does, or people introduce it with an intent of what they think it will mean and how they think it will work. And to watch how our witnesses illustrated where there were some significant shortcomings with this legislation, and to see how you could illustrate that something on paper may not exactly be achieving what was intended in practice. And that I think was really meaningful, and that's sometimes an opportunity that people don't get at this stage. And so that was also really powerful to see that being effective in the stories or the messages that were being relayed through our clients.
Yeah, and I'll just be back on that really briefly to say, many of the points and arguments we made in the litigation are points our clients, witnesses, this community has been making for years in the legislature, through other audiences. And, it wasn't we added a different legal tactic, right? A lawsuit, and sharing that testimony in a courtroom meant something. Having, a judge listen and having our clients, allowed to tell their full, to the extent, time allows, their full story, I think it's like, okay, someone now, it does feel like someone is listening. I think that was like a key difference from maybe what they had been experiencing in sharing a lot of the same information and stories in other fora earlier.
Thank you for that. What you both are describing sounds incredibly powerful, incredibly impactful, and incredibly moving. So I would imagine that the words of the witnesses truly resonated within the halls of the courtroom. And what you described, Kersha, really just gave me chills with the pule and everything surrounding yourself and the team in blessings and protection. So truly very powerful. Um, with that said, can you take us through the court's ruling and what the outcome was?
So ultimately the court, as Hillary mentioned, we were asking for a preliminary injunction while the trial in this matter was still pending, the trial on the substantive issues. So the court ultimately granted in part our request and denied in part. And the part that she did grant the injunction, which was a statewide injunction enjoining the state from enforcing or taking enforcement action or enforcing penalties against specifically cultural practitioners. So what I mean by that is that with respect to the traditional and customary practices component of our arguments, the court found that there was a likelihood of success on the argument that this legislation unreasonably regulated traditional and customary practices. Traditional and customary practices, Native Hawaiian traditional and customary practices are affirmatively protected under our Hawaii state constitution. That's Article 12, Section 7. And under that constitutional protection, while there can be regulation of that practice, it still has to be balanced. And what the court did in its decision is it went through the analysis that was laid out in that case law to identify what were the rights that were at issue, how were they being impacted, and whether or not there were mitigative steps taken to address that impact. And what the court found here, and why this is significant in this order, is that the court looked at this legislation and the language contained within the legislation that said, essentially, we've considered that there's potentially impact to Native Hawaiian traditional and customary practices, but we are going to say that practitioners should not be prohibited from engaging in their practices so long as they are recognized under this specific pathway that the legislation set out, which was through recognition by a kupuna council, recognized by an organization named as Papaʻololokahi. So it was clear from the language of the legislation that the court felt it was clear that the legislature considered that this could have an impact. And the legislature was saying this should not impact the ability of practitioners to engage in these practices. But what the court did was look at, again, in practice, is that protection being realized? And what the court ultimately found was that at this point, practitioners are not protected, because there was no way for practitioners to be recognized through the Kupuna Council pathway. So ultimately, the court's ruling was that until such time that a Kupuna Council can be formed that can recognize practitioners, that the state must be enjoined from enforcing any penalties against cultural practitioners. So specifically with respect to the language of the order, the court found that those individuals who were protected were those who practice, teach, and learn pale keiki, hoʻohano, and hanau, or traditional Native Hawaiian healing practices of prenatal, maternal, and child care. So it was anybody who was engaged in practicing those Native Hawaiian traditions, teaching them, or learning them. And also with respect to the Kupuna Council, as I indicated, the court stated that the injunction was limited to the extent that it remains in existence until there is a pathway that cultural practitioners can take advantage of, as far as being recognized and therefore exempt from licensure under this particular law. So there were specific points I just wanted to highlight. The court characterized the obstacles that cultural practitioners were facing as insurmountable obstacles, essentially barriers that could not be overcome despite extensive efforts by our clients to engage in that practice. The court also made it very clear that while the legislation indicated that it was intended to not prohibit healing practices by traditional Hawaiian healers, that this promise has held untrue. That's a direct quote from the court. And that ultimately practitioners were left without an actual and meaningful pathway to exercise their traditional and customary rights, which ultimately caused irreparable harm through the threat of enforcement. And that suppressed our clients' constitutionally protected cultural practices. So this harm, the court identified as not just the harm of being unable to engage in a practice, but it was the potential extinction of the practice. It was the harm to Hawaiian health, Hawaiian well-being, Hawaiian spiritual and traditional beliefs, customs, and practice. And ultimately, one thing the court said that was significant is that a preliminary injunction granted on that ground benefits the public interest because of its ability to allow cultural practitioners to continue serving areas, rural areas, or areas that were being impacted by lack of access to maternal health care. So the court's decision, while it wasn't everything that we wanted, and to that extent, it was bittersweet, the part that she did grant in our favor was really powerful. And it does mean that practitioners, cultural practitioners, can exercise their constitutionally protected right to engage in this practice until there is another pathway that will allow them to do so under the protection of the law. I do want to note that when I talk about Article 12, Section 7, which is our Hawai'i Constitution amendment that protects traditional and customary practices, it does say that those practices are ones exercised by individuals who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. So that is written directly into our Constitution. So when we talk about cultural practitioners and the court's order, it harkens back to that language of that constitutional protection and who it extends to.
Thank you for that.
And if I can just add, I feel like we cannot underestimate sort of the power that the court's order has for our Native Hawaiian clients. So one of them, when we talked to her to share the news, said, so we can go back to being who we are. I think that encapsulates so much, Kirsha, of what you said earlier about culture and identity. And that is, again, just reflected in how our clients speak about the importance of these protections.
And it's also infused throughout the court's decision on that ruling, which that in and of itself, I think as their legal representatives, it was really humbling to have the court understand that we weren't just talking about, practices, that this was so much deeper than just the inability to engage in some conduct. It was really a disconnection from culture and identity. And the court's order seems to reflect that the court understood that.
I think this case is a really interesting example of the fact that the law is not black and white. And so, like the legislation, the way it was created, though there may have been a consideration, seemed to still be missing the cultural impact it would have on Native Hawaiians. And so the work that you did was so crucial. And honestly, in a place like Hawaii, almost surprising that it was needed, that more consideration wouldn't have been given from the cultural perspective. So just really fascinating, I think, with a legal lens on it, but also with the importance of culture in Hawaii, just a really interesting mix that this case is representing and that you all are talking about. I want to take a step back and ask a question kind of from a higher level. How does access to midwifery services impact marginalized communities that are experiencing disparities in access to quality health care? So I know that you touched on just accessing healthcare in a lot of these rural communities and what these midwives um, do for these communities. So can you discuss a little bit more about that?
Yeah, so I can start here. So I think the answer here is sort of about access to healthcare and healthcare providers, access to trusted providers, and really an ability to get care that meets your needs. So we know that the US is experiencing a crisis in maternal health and that women of color are bearing the brunt of the systemic failures that are causing that crisis. And Native Hawaiian and other Pacific Islander people have the highest rates of maternal mortality nationally, followed by Black and other Indigenous people. And in Hawaii, approximately half of pregnancy-related deaths occur among Native Hawaiian and other Pacific Islander people. And although they make up only a quarter of the women in the state. So we know this crisis is also preventable and what is contributing to it. So one is about access. Across the country, communities are facing maternal health care deserts where there are just not enough providers in or close to communities, and people are really struggling to access the health care they need. So for example, on Maui, there's one hospital. It is reachable from the east side of the island after a 2 to 3 hour drive on a single road that is often clogged with tourist traffic. Sometimes people give birth on the side of the road en route to that hospital. So some of our clients were some of the only practitioners traveling to rural and remote areas on Maui where the law criminalized their practice, but while taking away resources, did nothing to provide new ones, right? It was only taking away and not providing any supports or replacements to improve access to healthcare. And the second piece is that even when people ultimately access care, sometimes the care they receive is discriminatory, disrespectful, and in the maternal health context, really over-relies on interventions that risk their health and lives. In Hawaii, 27% of births are by cesarean surgery, which is more than double the cesarean rates recommended by the WHO, the World Health Organization. So absolutely, sometimes interventions are necessary, but when they're not, or when people don't understand the consequences of them, they're not informed of all of their options or feel coerced into procedures, that really, I mean, it steals their autonomy and really has also physical, emotional impacts on their health and lives. And people of color, of course, bear these harms disproportionately to their white counterparts. People of color in Hawaii and elsewhere report being racially profiled, referred to family policing authorities, or coerced into procedures, and just overall not feeling safe in a hospital setting. So I will get to the midwifery part of this, is that midwives and the midwifery model of care really addresses each of these, right? More midwives can expand access to healthcare. The midwifery model of care focuses on autonomy of the pregnant person, and evidence demonstrates that when there are more midwives practicing the midwifery model of care, there are fewer interventions. And as we've been discussing, midwives also play a critical role in empowering families to make cultural connections about pregnancy and birth. So in many other countries, midwives are providing the most care for people giving birth, and that care is associated with better outcomes and experiences. So we don't have to look far to understand, like the US has about 90% of births are attended by physician surgeons. We can shift that back to midwives, who were the original people who supported people throughout pregnancy and birth. The US has a long history and tradition of midwives supporting people during pregnancy and birth, and the law has pushed them out of practice. So we have a part of the case that we are talking about is about dismantling those barriers so that people, again, have the widest possible choices for where and with whom they birth, right? It's not one is better than the other, but people should be supported in whatever choice they make and informed about the options that they have.
For me, it keeps coming back down to choice. So, thank you for touching on that because truly, as a birthing person, you should be entitled to choose how you would, in fact, like to give birth from thine own body. So, a novel concept, I know. Let me go ahead and ask our next question on the topic of choice. How have recent US Supreme Court decisions impacted access to maternal health care in the United States? And also, if relevant, if you could touch on in the Pacific Territories as well.
Yeah, so I will start here with, in the last several years, we've had at least 3 major US Supreme Court decisions on abortion, but those each have absolutely impacted maternal health in the US. So the 3 cases I'm thinking of are, of course, Dobbs in 2022, and then this past Supreme Court term, the Alliance case about medication abortion, and the EMTALA case, which is about access to emergency care when that care is abortion. I want to say sort of 2 things. So one, on the legal side, sort of Dobbs as a legal matter obviously was a seismic change. So loss of even moderate protections for abortion rights put abortion further out of reach for many, many, many people. But the lack of affirmative protections for abortion rights and for maternal health rights has also really normalized the idea that pregnant people are not trusted decision makers, that their rights can be treated differently, trampled on or extinguished. And I think the cases this term, the Alliance case and the EMTALA case, although, they did not cause terrible outcomes, the court seems to have kind of punted this term. Both of them are evidence that the anti-abortion side is not satisfied with overruling Roe. We're not done yet. So in the Alliance case, anti-abortion physicians were trying to kick mifepristone, the medication abortion pill, off the market. In the EMTALA case, advocates are essentially asking for permission to let women die because they do not want emergency rooms to be able to provide emergency care when that care is abortion. And on the practical side, the human toll of all this has been absolutely catastrophic. And there is no distinction about the impact on abortion versus maternal health because many of the same people access that care, many of the same providers provide that care. So after Dobbs, we have seen healthcare providers just fleeing states with criminal abortion bans because it's a hostile place to be a healthcare provider. Labor and delivery units are closing in regions where that was already happening. It's getting much worse. People experiencing miscarriage in states with abortion bans are getting swept up in those as well. Miscarriage care and abortion care are essentially the same. Mifepristone is used in medication abortion. It is also a routine part of miscarriage care. So if it is no longer on the market, people accessing miscarriage care are unable to get, routine care just because that care is associated with abortion. And people experiencing pregnancy complications have, been suffering before and much more after Dobbs. We at the center represent, dozens of women across the country who have been harmed under state criminal abortion bans, many of whom with wanted pregnancies, and where the line between abortion and maternal health care is really indistinguishable. People have been turned away from emergency rooms or airlifted out of state to try to get care in another place because their state criminal abortion ban is making physicians concerned about losing their license if they provide what they deem as routine care. So try to recap, the government is really forcing people to remain pregnant in a country where being pregnant and giving birth can be a death sentence. And really the other side's idea that any of this is pro-life, right? This puts the lie to that sort of talking point that any of this is pro-life. What we have been advocating for in the Hawaii case, that is life affirming, and that I get to make my own decisions about a culturally significant moment in my life and pass on traditions to future generations. That is what it truly means to be life affirming and pro-life. So I will stop there. Clearly I could go on, because these distinctions between abortion and maternal health really kind of break down when we are talking about just simply the rights to control your own lives, bodies, and futures, and whether that decision is to end a pregnancy or continue it. We're really talking about the same thing.
All right. With that, I will start winding us down. In 1 minute, what would be your call to action for this audience? Trisha, do you want to go ahead?
I'll let Hillary go first.
Okay.
Okay, I'm not sure if this is quite a call to action, but it's echoing what I was saying a little bit before. That for me, sort of in reflecting about Dobbs, and it was a devastating loss. I can't sort of emphasize enough that it is not the final word on reproductive rights in the US. There are no quick wins here. We've seen that in this case with the really years that our clients have been fighting. And anti-abortion forces, right, in other contexts have worked for 50 years to overrule Roe. They have been relentless, and this may be corny, but so are we, and we can build for something better than Roe ever gave us, right? Part of the reason the center is involved not only in abortion cases, but in cases that aim to dismantle barriers to midwifery care is, again, as I was saying, these are the same rights, and the right to reproductive autonomy, the one we will build for, even if it takes 50 years, is one that actually supports people to make decisions throughout pregnancy and birth, whatever those decisions may be.
I don't know that I have a call to action either, but I think what this case really stands for, like Hillary said, is really this choice, right? The fact that that should be protected, who you choose to surround yourself with in these very intimate, sometimes culturally significant decisions that you're making. For Hawaiians, genealogy is so important. Where you come from, and then who you leave, right? Who becomes the next generation. And birth is that moment that connects those two times. And so to have the inability to surround yourself and utilize cultural traditions that connect you to your ancestors and to your keiki or your children that are coming from you is devastating. While Hillary was talking, I was reflecting on an observation that was shared by one of the witnesses about an individual that they knew that after the birth attendant exception under the law expired in July of 2023, that this woman chose to try and birth on her own for fear of trying to have somebody who was helping her provide care prior to the expiration of that exemption, did not want to subject them to the threat of criminal penalties or civil penalties, and rather risked self-birthing, birthing alone, then do that, and not going to the hospital where they may not be in honor or respect for the type of experience and practices that she wanted to be part of her birth story. And that, to me, I think just signifies all of the problems that we tried to identify and highlight for the court in this hearing. The overlap with the traditional and customary practices that were impacted by this legislation was also significant. For Native Hawaiian rights, I think this is a call to action for cultural practitioners to take the steps and be courageous to protect our ways of being and our identity and our culture. And that this case shows that sometimes when you do that, you can be heard. And we can give real meaning and effect to what our state constitution aims to protect through that language. And then the only thing I just wanted to share, I know there was a mention about, it's surprising that here in Hawaii, that this is something that we are having to go into court to explain and to advocate for. And these protections are relatively new. They were born out of a constitutional convention in 1978. So we're not talking about, centuries of having this part of our law, but I think that's why that call to action is important. The only way that we can continue to define and identify the contours of that protection and where it extends and what it covers and how it should look is through this type of work. And this case, as I indicated previously, was significant because it said it identifies or highlights that it's not enough to just say things are protected. You actually have to do that in practice. So be courageous.
I think that is the perfect place to end this. Thank you both so much for your time. Thank you both so much for the impactful work that you have done in this case, that you continue to do in other cases. And a credit to what you both have said, step by step, brick by brick, we will build back something better than ever was. So thank you both. To our audience, thank you for watching and engaging with our program. This series will continue throughout the year and address other significant components of reproductive rights. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at americanbar.org/CRSJ. Thank you for joining us, and thank you for taking the time today.
Thank you.
Thank you.